Hello, everyone, and welcome. We have an excellent program prepared for you today on lawmaking around the world in the time of COVID-19. We are joined by over 300 registrants from all corners of the globe. I'm Kimberly Faith. I am the chair of the organizing committee for the 2021 International Conference on Legislation and Law Reform. Our organizing committee is a group of attorneys who volunteer their time to put on an annual conference that focuses on how laws are written in the United States and around the world at the international, national, and subnational levels. So we are pleased to announce that we have set dates for our 2021 conference in Washington, D.C. It will be held 1 year from now on October 21st and 22nd. For more information on that, please see our website at www.ilegis.org. That's ILEGIS.org. So before we begin with our panelists, I would like to thank the University of Pennsylvania Carey Law School for participating or for partnering with us to create this webinar. I also want to thank Larry Shapiro and Kathy Pagano, two members of our organizing committee who have done an impressive amount of behind the scenes work to make this webinar a reality. Now I'd like to introduce Toby Dorsey, the moderator of our panel today. Toby is an accomplished scholar that has had an impressive career across the executive, legislative, and judicial branches of government. He joins us for this panel from the White House, where he is the managing counsel for legal policy in the Office of Administration in the Executive Office of the President. So Toby, thank you so much for agreeing to moderate our panel today. And with that, I will turn it over to you.
Thank you, Kim, and thank you everyone for being here. Before I go any further, let me make clear that I'm appearing here in my personal capacity as a lawyer with an unusual passion for legislation. The remarks I make today are my own and do not necessarily represent the views of the Executive Office of the President, the White House, or the Office of Administration where I work. We are very privileged today to have three very distinguished speakers, and this is how our panel is going to work. First, we are going to look broadly at how legislatures around the world have been impacted by the pandemic. Then we are going to take a deep dive into how this problem looks in the United States, and specifically how it has affected the operations of the House of Representatives in the US Congress. Finally, we're going to turn from the question of legislative process to the question of legislative output, and what special considerations are involved when legislatures are drafting laws to address an emergency situation. So we are going to have a discussion for the next hour to an hour and a half. I invite you to send me questions using the Q&A feature, which is at the bottom of the Zoom bar. Please feel free to do this while the speaker is talking. I will be collecting the questions and holding them until the speaker has finished the presentation, and then I will pose a section of questions to the speaker. We'll do that 3 times, one for each speaker. And then all speakers have made their presentations and answered questions. The 4 of us will have a bit of a roundtable discussion, and I should have an opportunity then to fit in some additional questions for the group. So without further ado, let me introduce our first speaker. Our first speaker, and I need to take a deep breath before I do this. Our first speaker is Dr. Etai Barcimentov. He is a senior lecturer at Bar-Ilan University Faculty of Law in Tel Aviv. He's the head of the BIU Innovation Lab for Law, Data Science, and Digital Ethics, a member of the executive board of Bar-Ilan University's Data Science Institute, and co-director of the dual degree program in law and political science. He is also a senior fellow in the Jean Monnet Center of Excellence on Digital Governance, the general editor of the international journal, The Theory and Practice of Legislation, and founding co-chair of the Israeli Association of Legislation. So without further ado, please join me in welcoming Dr. Bar-Siman-Tov.
Thank you very much, Toby. And before I begin, I want to thank Penn Law School and especially Neoshi for great work, and our friends in iLegis, Kim and Larry and Kathy for inviting me to speak today. I'm very happy to be here. What I'll start saying is talking as just trying to share screen while talking. Just a second. So as Toby said, I'll talk more generally about how COVID-19 challenges legislatures. And one of the things that we saw as COVID-19 began is that, of course, people sounded the alarm about the health risks. Then people talked about the economic repercussions, etc. But one of the things we began to see, even in March, and even more so in April, that another less known victim of the pandemic or casualties of the pandemic have been legislatures. And it turned out that legislatures around the world have been either closed or significantly limited their activity because of COVID-19. To the extent that one estimated in the beginning of April that over 2 billion people around the world lived in countries where the parliament or legislature was closed due to COVID-19. So I will focus my brief talk today on trying to explain why COVID-19 is such a challenge for legislatures. And my argument would be is that the problem is that COVID-19 interacts with several various features of legislatures, and this interaction creates a novel challenge, and that's how you can see the novel coronavirus is also a novel challenge for legislators. So let us begin. So at this stage in everybody's life, I think in the world, they don't have to introduce what COVID-19 is and its features. I'll just say that one of the things that we know is that there's no vaccine yet. And most countries, the major way to deal with COVID-19 was non-pharmaceutical interventions and mainly social distancing measures. This is the reason that instead of being in wonderful Washington, DC, we're all now doing this through Zoom, right? Because the main approach to deal with COVID-19 is to try to stop spreading the transmission of the virus by social distancing. Social distancing meaning, among other things, prohibiting assemblies and sometimes quarantines, travel restrictions, etc. Now this stands in stark contrast to legislatures. Why? Because legislatures, by their very definition, institutional character, are a place where people gather. Think about the name Congress, all right? Or in many countries or state assemblies, it's called assembly, right? In Hebrew, it's called Knesset, which means, again, bringing a lot of people together. And this is what legislatures are all about, bringing a lot of people together to sit together, debate, and vote, right? What you see here, for example, in the picture is the Israeli parliament, the Knesset. So the first thing that we see is that COVID-19 and the major means to restrict COVID-19, the health measures, are in stark contrast with legislatures' basic institutional features. To add to this problem is that many legislatures have parliamentary rules or legislative rules that include, among other things, the rule of quorum. And in many places, it's mandatory constitutional requirements of quorum, meaning that legislatures could not operate if they don't have enough people sitting together. And traditionally, this requirement for quorum was interpreted in most of the world as sitting together physically, which of course creates challenges for remote voting, for remote operation, Zoom parliaments, etc. I won't go into more details on this because you'll hear an excellent lecture after me that will talk specifically about that in the case of the US Congress. But my first point is just to say that COVID-19 and the restrictive health measures to deal with COVID-19 are in clash with what legislatures are all about and their institutional features. So this is the first challenge. The second challenge is that COVID-19 is actually dangerous. It's dangerous to all of us, but in some respect, it's even more dangerous to legislatures. And we in fact know from various countries that the percentage of politicians and legislatures that were found positive to COVID-19 is higher than the rest of the population. There are various explanations. Some of it is perhaps they're tested more, right? But still, we know one of the things we already know about COVID-19, that it does not affect everybody the same way. We know that usually younger people who have no background health issues are relatively immune from the disease, while people who are older and male, older people are in demographic groups that are at higher risks. Now, if we know what are the demographic traits of legislatures, we know that they tend to be older than the population. We know that they tend to be more male. And we know that their whole job is meeting people all the time, shaking hands, being in interactions. So they're in fact, to some degree, not only in danger like all of us, but even a bit more in danger. In some parliaments around the world, it might be even more dramatic. Just to give you one example, in the UK House of Lords, the average age is 70. So you can understand how the legislatures there are in a serious danger group in terms of their demographics. Okay, so we said that institutionally, there's a challenge for legislatures because of their institutional traits of how they operate. And when it's combined with the demographic traits of legislatures, it's not only institutionally difficult to operate under COVID-19, it's also dangerous, okay? But although I said until now that there is a risk, and we know, by the way, we saw around the world that there are places that high-ranking politicians, from Donald Trump to the Prime Minister of the UK or the Speaker of Parliament in Iran and many others, a lot of politicians were actually infected, and in some parliaments, over 20 members were infected. So there is a risk, and still, I argue there's also a risk of overestimating the risk. And here my argument is that there is an interaction between COVID-19 and its features, especially when it only began, it was new and frightening and unknown, and what's called the literature about risk perceptions and the danger that legislatures will overestimate the risk of continuing to operate and will take a disproportional response and close down entirely. And again, I'm not one of those saying that there's no risk and that COVID-19 is not real or anything like that. I'm saying there is a risk, and there should be proportional measures to meet that risk. But the risk here that I'm talking about is overestimating this risk, okay? And my argument is sometimes social media and even established media can create an even exacerbating force of causing an overestimation of the risk and therefore disproportional response. And because we're short on time, I'll just show brief examples, okay? So take a look at this example. This is from the website of BBC. If you can see the title, it says coronavirus, and then talking about a coughing fit in Parliament, and you see a big picture of a guy coughing in Parliament. The story here is that it's an Australian federal treasurer who had a coughing fit during his speech in Parliament. And of course, you know, it looks very dramatic, very frightening. This story about a guy coughing in Parliament in Australia was broadcasted around the world in CNN, BBC, Sky News, all the major newspapers, over 300 media outlets. Now I give you a free eye exam, okay? Look at the bottom of the fine print. Can you read what it says? Okay, what it says is that actually he was tested for COVID-19 and the result came back negative. So this is a known story, right? It's a story about a guy who coughed and it had nothing to do with COVID-19. But when you see this drama and you see this, and it's a video of 3 minutes of him coughing in Parliament, this of course exacerbates the feelings of danger, even when it's not correct. And my argument is that it actually does have an impact. And here's just one example because we're short of time. Here's a headline from a newspaper. Kenya, and you can see the headline: Panic hits Parliament as 17 MPs test positive for COVID-19. Again, free eyesight exam. Can you read the fine print? The fine print says, but Senate Speaker dismisses claims of confirmed coronavirus cases in Parliament. It turned out that this was fake news. The story there is that at first they closed Parliament because of fear of COVID-19. Then they wanted to have a special meeting of Parliament. They started testing some of the MPs, and then stories came out and newspaper reports that 17 MPs were tested positive, but there was just a major, one major problem, that this turned out to be fake news. And in fact, Kenya was not hit, Kenyan parliamentarians were not hit by COVID-19, they were hit by a virus, massive virus infection fears, okay? So again, I'm not saying there's no real risk, I'm just saying that parliaments may overestimate the risk and take disproportional measures. And we see this around the world. For example, again, we're short on time, I'll give just one example. In Australia, their initial reaction was closing down Parliament for 5 months as a reaction to the pandemic without leaving even one virtual committee to have some oversight of the government. Okay, now what's the problem? Until now, we saw it's very difficult for the Parliament or the legislature to operate under COVID-19. But the problem is there's no vacuum, right? What happens is that when the legislature is not operating, who comes into the picture and takes advantage of the situation? The executive branch. And we know from previous research and previous experience that in emergencies, the executive branch tends to try to do power grabbing at the expense of the legislature. And in this case of COVID-19, the situation is particularly dangerous because we have the classic case where in all emergencies, the executive branch is tempted to take more power. At the same time, Parliament or legislature, as we just saw, is having a very difficult objective time to operate. And the combination, of course, makes the legislature even weaker and at the end, democracy even weaker. And we saw it around the world. You know who this guy is? This is Viktor Orban, the Prime Minister of Hungary. He made a lot of headlines because of arguments that his government used the coronavirus for more power grabbing and further deteriorating the democracy in his country and the executive taking more and more power. But the amazing thing is that we see it around the world, even in countries who are not the usual suspects, right? For example, who is this guy? This is your neighbor to the north, right? This is the Prime Minister of Canada. And the amazing thing is that even in Canada, we see evidence of the government trying to use the situation to do power grabbing. And for example, in March, when Parliament had to, the government had a bill in Parliament to pass bailout legislation that everybody agreed was necessary to help Canadians who were out of jobs. But it turned out the government added another provision that would have let government to raise taxes, lower taxes, expend as much money as they want, borrow as much money as they want, without parliamentary approval until December 2021. But fortunately for Canada, you know, they have a very robust democracy, and there was a lot of backlash, and Parliament opposed and the media opposed, and eventually the government decided not to go through with it. But the fact that even a liberal constitutional democracy like Canada, headed by a liberal prime minister, attempted such power grabbing shows that the risk, as David Eisenhower has put it, is omnipresence. Omnipresent. Okay? So to conclude, we see that COVID-19 is a very serious challenge for legislatures. The combination of the feature of COVID-19 with the institutional features of legislatures, the demographic traits of legislatures, the risk perceptions that we tend to have, and specifically about COVID-19, which is new and unknown and invisible, right, and frightening, means that it's actually very challenging, really dangerous, and daunting and frightening for parliaments to act. And at the same time, parliaments are threatened by the executive branch, which is tempted to do more power grabbing than usual. This creates a very serious challenge, but I want to conclude with optimistic conclusions, saying that what we've seen since the beginning of the pandemic around the world, that a lot of the parliaments, despite these challenges, have shown great abilities to adapt and to operate despite these grave challenges. And it's vital that parliaments would be able to do it, because as the president of the Parliament of the EU has said, a virus cannot bring down democracy, Parliament should not close because a virus cannot bring down democracy. So after me, you will hear specifically how one legislator in the US Congress has adapted and dealt with this challenge. But my point is that on the one hand, we have to appreciate the challenges. On the other hand, we have to be optimistic about the importance of parliaments being adaptive and resilient in these times. Thank you very much.
Thank you, Ittai. That was very, very interesting. And I apologize for not being able to give you more time, because I'm sure we could spend an hour and a half on this subject alone. It's fascinating, especially in these times while we are in them. So let me ask you a couple of questions before we move on, and give you a chance to expand on some of your remarks. So first question, you talked a lot about the power grabbing that the executive has a tendency to power grab from the legislature. Is there also a tendency for the legislature to push power to the executive, that they are? Is it sort of an inherent feature or flaw of parliaments that they are trying to push accountability and push power to the executive?
Thank you, Toby. So this is a very good question, and I completely agree. It's not only the executive branch's fault, it's also many times the fault of legislatures, because among various reasons, part of it, as you hinted, I think it's try to avoid accountability. Part of it is our bias to be risk averse. But I completely agree that we do see in many places that parliament sometimes relinquished their powers and actually gave their powers, sometimes to the executive, sometimes also to medical experts, and letting the experts tell the elected officials what should be done. And it creates a challenge of to what extent we need to let the executive branch and its experts to be effective and act expeditiously, because we know that it is required. But on the other hand, maintain the very important democratic role of legislatures in holding the executive accountable. And the good news is, although I agree with you that we see this type of things around the world, we see in many cases that actually parliaments did enact legislation, but this legislation just granted a lot of power to the executive. On the other hand, what happened, and we saw that in Israel as well, is that in some places, even for the legislatures themselves and the public and the media, in Israel also the Supreme Court that intervened, there was a heightened sense, even more than in usual times, how important and crucial it is to have an operating parliament, especially during this emergency. So it worked, I think, both ways.
Excellent. So I see a couple questions in our Q&A about the extent to which the executive actually has a legitimate role of special leadership and has special powers in times of crisis and in emergencies. That this is, in many constitutions and in many frameworks, this is seen as not only legitimate but desired. How do you reconcile those ideas with the idea that Parliament needs to be accountable and present and at some level be in charge?
So this is, of course, a very important and challenging question. I think we all agree that the executive has to have more powers than usual. I think we all agree that measures that in everyday life, in normal circumstances, we would not allow our country and government in general, all branches of government to take, are sometimes required and even necessary. Having said that, there's a dangerous tendency that happens always in emergencies, and I saw it around the world in this crisis as well, of people saying, oh, let's do away with parliaments or all those checks and balances. There's no time for that now. We have just to be effective. And I think this is very dangerous. And by the way, I've seen it around the world. Just to give one anecdote of an example, the editor of The Lancet, right, one of the most important medical journals in the world, he started by writing in the beginning of the pandemic that it's not a serious pandemic, and then wrote a few months later, governments should have the power to do much more, and the UK government is not doing enough, and eventually saying we should all be like China. And when I see people in the democratic world saying, oh, we should be like China, I'm afraid, right? So I think there's a very grave danger of saying because we want to be effective to deal with COVID-19, that we want the executive to be too powerful, and we want to enable it to weaken the parliament. And the grave danger is that those changes would remain after the pandemic will be over, and the pandemic will be over eventually, of course. So this is one point. The other point, if I have time to add, is that so the first point is that even if it's true that having parliament around makes us less effective in countering the pandemic, I'm saying this is a price worth paying, because some people say we need to fight COVID-19 as if there's no democracy. Some people say we have to fight for democracy as if there's no COVID-19. And I think, of course, the correct approach is that we have to find a combination between the two. So even if it's a bit less effective to have parliament involved, it's worth the price. So this is the first point. The second point is that it's too common and too easily accepted by everybody that having parliament around would make us less effective. And I think in many respects, actually, the involvement of parliament could help the effectiveness of the measures. To give just one example out of a few arguments is that we know that to a very large extent, the effectiveness of the measures depend on their legitimacy and the willingness of the people to actually abide by those very restrictive limitations around the world. One of the things to add to the legitimacy is, and there's a lot of course, scholarship showing us that if people perceive the process in which the measures were taken as legitimate and democratic, they would be more willing to abide by the limitations. And therefore, the fact that parliament was involved and there was a democratic, accountable process would actually make the measures more effective. I'll just say that in some countries, we even see that a bit unlike what I gave as most of the examples, in some countries, actually the head of the executive branch was the one who did not take this pandemic seriously, and it was actually the parliament that held the head of the executive branch accountable, told them, listen, you have to take this seriously. I won't say anything about the president of your fine country. I could say that we could use Brazil as an example as well, even the UK in the beginning. So sometimes parliament is actually the body that says, listen, there is a problem here, take it more seriously.
Excellent. Thank you so much for your presentation. I'm getting some comments that this was an excellent presentation. I totally agree. I want to ask you one more question now, because I think it is really specifically for a good question for you. And there's another question that I'm going to hold till the end, because it's more about the recommendations that all of our speakers, I think, would make going forward. So, but the question for you, I think, Ittai, is anyone monitoring this in a systematic way? Like, is there sort of a government response event data set or anything like that? You're familiar with, big data is one of your things. Is there any effort to catalog and monitor this? How parliaments are handling these things?
So So yes, fortunately, there's a lot of important NGOs doing this work. Among other that I could mention is the Inter-Parliamentary Union that has a website that catalogs it, but there's also academic efforts, and I'm part of a research group. I did not have time to go. I just presented one of my articles. This is a very large research project, and I have had many projects. And one of them is an interdisciplinary project with other scholars from various fields, including medicine. And we actually did an empirical cross-national study that we examined all countries around the world with a population over a million, which means almost 160 countries. And we checked the operation of parliaments under COVID-19 in each of those countries. And nowadays I know, and because I'm also part of other projects, that there's also additional follow-up projects going around the world. I think it's very important to monitor those things. Like I should also mention that my good friend Ronan and I have also edited 2 special issues that give a comparative aspect. One of them is legislatures in the time of COVID-19, which has just been published. And you're more than welcome to go to the website of the Theory and Practice of Legislation, look at it. And the other one is forthcoming, called Global Legislative Responses to Coronavirus, which what Ronan will present would be relevant more to that aspect. So the short answer is yes, it's very important to monitor, and us and many others are now doing that.
Terrific, and thank you again for your presentation. We will see you again later after the other speakers have gone. And I now want to turn to our next speaker. So our next speaker is Noah Wofsy. He has been an attorney with the Office of the Legislative Counsel of the U.S. House of Representatives since what my teenagers refer to as the 1900s. Since 1986, he has served as Deputy Legislative Counsel since 2018. His primary subject matter areas in legislative drafting have included election law, campaign finance law, laws affecting the legislative branch and the internal operations of Congress, and laws relating to the home rule status of the District of Columbia. He's also worked on healthcare legislation, including the so-called Clinton healthcare reform proposal and many other ill-fated attempts at comprehensive health insurance reform. For several years, he was a member of the adjunct faculty at the George Washington University Law School, where he taught a class on legislative analysis and drafting. And he is a regular presenter at legislative process programs in a number of venues. And I should point out that if it seems that I am treating Noah in a familiar way, it's because for 10 years, we were colleagues in the office of the House Office of Legislative Counsel. So we go back pretty far. So please welcome me, please join me in welcoming Noah to talk about what's happening in the US Congress.
Thank you, Toby. It's great to have the opportunity to work with you again on this program. And it's great to have the opportunity to talk to everybody about what's happening on the Hill, what's shaking on the Hill, as they say. And what I want to start with is sort of a basic premise that you can look at the premise or the goal of the House and how it's operating during the pandemic as basically trying to preserve regular order. In other words, that the House should be continuing to do whatever it is it does, only to do so remotely, so that the members and staff and everybody don't have to actually appear on campus to get their work done. Now, of all the offices in the House, I think that my office, your former office, our office, the Legislative Counsel, is probably best equipped than most to operate under these conditions, because we've been working remotely for a long time, well over a decade, dating back really initiated by the old anthrax attacks that hit Capitol Hill in the fall of 2001, started the process by which the House made sure that our office could work remotely. Other offices of the House have adapted a little bit more slowly, but the House has made a concerted effort to make sure that each office has at least the technical capability of working remotely. The House has provided these offices with platforms such as Microsoft Teams, Cisco WebEx. It's provided additional equipment, supplies, and training so that ideally House offices can continue operating on a remote basis. So obviously that sounds so nice and simple. Hey, let's just all work remotely. But there are a couple of reasons why it isn't always that simple. One of which are just the factors that everybody has been encountering who's been forced to work remotely. When you can't go into your office, you've got problems with childcare. If your kids can't go to schools because the schools are closed, if you're dealing with other family household situations, and of course, the competing demands on broadband access within the home, everyone wants to use the Wi-Fi, not to mention just the unending sameness of being in the same place every day with the same four walls staring at you. It never, ever stops. You know, just the general problems and challenges there are to working remotely. In the House, there's an additional layer of challenges, though, which is that member offices in the House are very much like little individual fiefdoms, especially when it comes to how members carry out their personnel policies and how they operate. And we have a lot of anecdotal evidence, certainly in my experience, communicating with clients who work for individual member offices. Note, this is mostly individual member offices I'm talking about, not committee offices or leadership offices. People who work for individual member offices, when you propose to them that, hey, let's have a conversation on Microsoft Teams, they'll say, well, actually, our office isn't really working with that, and I have to give you my cell phone number. Or I've been communicating sometimes with clients who work for individual member offices who have told me that they are actually in their office at the time that we are communicating. I'm sitting at home, they're on Capitol Hill, and it's mostly because their bosses like it better when they are actually physically present. So there are some complications unique to the House in terms of moving on a remote basis, but it is safe to say that that's been the goal. And as Itai sort of alluded to, there have been efforts in the House to address the question of how to operate in the pandemic. First and foremost, the House adopted a resolution back in May, House Resolution 965. And what this resolution does is to say that when there's a public health emergency in effect that's tied into the coronavirus, note, by the way, that that determination is made by the House Sergeant at Arms in consultation with the attending physician, like the medical director of the House, not by the leadership directly, but by the Sergeant at Arms and the attending physician. That's going to be a factor as I continue later in the talk with some other factors that have been going on and how the House is operating. But while this emergency is going on, basically two things can happen. First of all, members may designate other members to vote for them and record their presence in the House by proxy. In other words, to cast recorded votes and to record their presence for purposes of the determination of whether or not there's a quorum. Members can designate other members to do so by proxy in the House. Secondly, committees of the House are given full authority to operate remotely, meaning that the members, the staff, the witnesses don't have to be in the big committee hearing rooms. They can come in through Cisco WebEx, through email, through whatever devices the committee uses and participate remotely, including by casting votes in committees, votes to report out bills, votes to vote on amendments offered to the bills when the bills are being marked up. I want you to be aware, though, that the flip side, the inverse converse of this is not true. In other words, the House resolution does not permit proxy voting in committees. That's against the House rules, and it remains against the House rules even under House Resolution 965. Members cannot vote by proxy in committees. And similarly, conversely, inversely, whatever, members may not vote remotely in the House. The House in the chamber does not have the authority to act remotely. Now, what the resolution does is direct the Committee on House Administration, sort of like the committee that's in charge for the internal operation of the House, to study the issue and determine, I didn't memorize this, gotta forgive me, I gotta look at my notes here, to determine whether operable and secure technology exists to conduct remote voting in the House. In other words, study it, make a determination. If it just so happens that the committee makes that determination, that this operable and secure technology is available to permit remote voting in the House, the committee will notify the Rules Committee, meaning the House leadership. And the Rules Committee will then proceed to develop and issue regulations under which remote voting will happen in the House. So it could happen in the future, but it hasn't happened yet. And because remote voting doesn't exist in the House, there actually has been a fairly significant effect on how the House has considered legislation, specifically and primarily in the case of complex bills. Bills that are subject to a lot of demand for amendments, especially. Why is this? Well, as House Sergeant at Arms, working with the attending physician, has come up with a rule that limits the number of individuals who can be present in the House chamber at any given moment. There's a limit on how many people can actually gather in the House. Ittai showed that picture of the Knesset, I think, before, and everyone's gathered together. The House Sergeant at Arms and the attending physician prohibit that kind of gathering. So when you look at how the House considers complicated bills that are subject to a lot of amendments or a lot of demand for amendments, how did it work before the pandemic? Well, what would happen would be the House would take up the amendments to a big bill. They would debate the first amendment, and then once the debate was finished, they would suspend the voting on that amendment. They wouldn't take a recorded vote on that amendment until debate on other amendments had already occurred. In other words, they would go on to the next amendment on the list, then the next one, until there was a critical mass of amendments. Then there'd be the first call for the first recorded vote on that first amendment. That vote was given 15 minutes. Members were given 15 minutes to record their votes on that first amendment. When that first amendment vote was finished, the next recorded vote was given 2 minutes. And the next one after that, 2 minutes. In other words, once you get that first vote out of the way, knock them out. Why? Because everyone is there. Everyone's present in the chamber. You've got that critical mass of humanity, or mass of whatever members are, all together. So why not get the votes out of the way and take care of it all? The House can go through a lot of recorded votes in a fairly quick period of time. How does it happen now in the year of the pandemic? What happens instead is that members are told that when recorded votes are expected in the House, to be ready to go to the House in groups. Members are assigned to a specific group based on alphabetical order, basically 6 groups of approximately 72 members each, plus 1 extra group for those who couldn't make it to the House floor when their assigned group was called. Each group is given 5 minutes to vote for the entire group. Until the group is called, members can't enter the chamber. Once the group is called, the members are told, get in, vote, get out. Get out. Don't dawdle. Get out of there, because we got the next group to go through. So I'm not a math person, but by my calculation, that means, or one other thing I should probably mention, as part of that process, all those members who are voting by proxy have to stand up and announce that they are voting by proxy and to say on whose behalf the proxy votes are being cast. So this means that each recorded vote in the House now, under the pandemic, takes 35 minutes. 35 minutes for a single recorded vote. Obviously, what the House has to do in order to operate is limit the number of recorded votes. Even on complicated, complex amendments, bills, for which there's a tremendous demand for amendments. There are lots of examples to compare and contrast between how the House did its business with a bill last year and this year. I'll just give one example here. Financial Services and General Government Appropriations Bill. This is one of the 12 appropriations bills that Congress regularly considers and enacts before the beginning of each fiscal year to fund the government. Anyway, so last year, the Financial Services and General Government Appropriations Bill, okay, 46 amendments were made in order on a single bill. It was taken up as a single bill independently. 46 amendments were made in order under the rule providing for consideration of the bill. There were 10 recorded votes taken to deal with those amendments. Some of the amendments obviously were done by voice vote. Those recorded votes took less than 2 hours, and the House adopted the bill and passed it. This year, Financial Services and General Government Appropriations Act bill was combined with 6 other appropriations bills into a 7 appropriations bill, so-called minibus, or I like to call it the short bus, so that all of these 7 bills are being considered en masse. How many recorded votes were taken on a 7 appropriations bill package this year? How many recorded votes? 3. 3 recorded votes on a 7 appropriations bill package, compared to last year when you had 10 recorded votes on a single appropriations bill. Does this mean that fewer amendments were actually considered? No, because 340 amendments were dispensed with in those 3 recorded votes, plus additional voice votes. What's happening here? Among other things, the House leadership is aggressively and assertively combining and packaging amendments that are made in order to bills into en bloc packages, so that a single recorded vote actually will determine the adoption or rejection of perhaps dozens and dozens of amendments, all blended together on the basis of however the leadership and the Rules Committee chooses. Some interesting implications from that. I'll just give one example. There was a bill that the House took up recently, HR 4447. It was about clean energy, which is a great thing, we know. So it's a complicated bill, long, difficult. Lots of amendments were demanded. 98 amendments were made in order. The Rules Committee said, these are the amendments that are going to be made in order, 98 of them. Now, of those 98 amendments, 12 were offered by members of the minority party, which is par for the course. The majority determines whose amendments get made in order, but 12 minority Republican members had their amendments made in order. The bill was taken up on the floor through a series of 4 en bloc amendments. 4 amendments where various combinations of these 98 amendments were put together. One of the en bloc packages consisted of 26 amendments, 3 of which included amendments offered by Republican members. 3 of those 12 amendments that I had mentioned before. So you would think, hey, if you're a Republican member, it's pretty exciting. It's pretty rare that the majority is going to let you offer an amendment on the floor. This is a great thing, right? How did those 3 Republican members vote on the amendment that included their own amendments? They voted no. In other words, members voted against their own amendments because presumably they didn't like the packaging of how their amendments were combined with other amendments, and it tipped the balance so much that they voted against their own amendments, amendments that they typically might not even get a chance to vote on if the majority party really wants to have its way. Now, I want to conclude by saying, because I know many of you have experience with the House and with other similar institutions, that this is not new. The idea that the majority, that the leadership of the House has a vice-like grip over how legislation is made, that's not a new thing. That's in fact basically how the House operates. What's different now is that there's a public health emergency, a public health reason why it's necessary, perhaps, for the leadership to maintain that grip on things. So what I'm really curious about, and what I'm very eager to see, is what happens once the emergency ends. I'm very eager to see the emergency end for many reasons, but among them is that I am very curious to see how the House is going to go back, if it will go back, to the time in which there was no remote voting in committees, there is no proxy voting, and amendments will almost typically be packaged together en bloc in order to limit the number of recorded votes in the House. I think it's going to be very interesting to see what happens. That's it.
Thank you, Noah. That was really wonderful and very interesting. You have a very interesting job and you work at a very interesting place. A couple of questions have come in, and I want to be sure that I ask them before we move along. But I have a question for you first for myself, and that is, I'm wondering if you can share with us what are the actual sort of hard constitutional limits on what the House can do in this environment? And are there, but what are the actual provisions of the Constitution that govern this about quorum and place of meeting and that sort of thing? And are there sort of creative lawyering going on to rethink how we should be applying those in the current situation or in the modern age generally?
Yeah, the answer is that there are some concerns and that the House has been creative in trying to address them. It's more, I think that the assumption is that the House will base most of its actions on the constitutional authority, the authority that it has on the Constitution to conduct its own rules or conduct its business under its own rules and proceedings, which is read very, very broadly. Basically, anything that the House does in terms of how it operates is left entirely to the House. And it works the same way in the Senate. Where there's squeamishness, the House has sort of stepped in to adopt or at least leave a paper trail about something, for example, like a quorum call. That's why House Resolution 965 says that members may not just cast votes, but record their presence in the House by proxy, just in case there is some challenge to the existence of a quorum or how a quorum is determined. The House is basically saying, under our authority to operate under our rules and procedures, here's our rule. People can record their presence remotely. That means, as far as the House rules are concerned, you're present, which means we have a quorum. How a court may interpret that if somebody's going to challenge it, it's unclear, but you can clearly see that that is sort of the hook that the House is using to cover its tracks in case there are problems. The House has also adopted resolutions at times that authorize the House to meet outside of its usual place of meeting. I remember just testing my memory, which is a very dangerous thing, but I have a vague recollection about the House taking up a resolution that would allow it to meet for a ceremony. I think it was the 200th anniversary of the ratification of the Constitution, that people wanted the House to meet in Philadelphia, and have like a ceremonial meeting. So there's been talk about doing things like that. I will say that there are definitely provisions, and without having the guys in the coats come to take me away here, that the House has made provisions for what to do in case the chamber is inaccessible, so that the House can have an alternative meeting location under emergency situations. So the House believes, I think, that everything is covered, but has any of this been challenged in court? Not yet.
Okay, great. Let me see if I can rapid fire move through a couple of questions that we have in the chat. So, has there been any movement to allow proxy voting in committee?
It was discussed, and the idea was that if you have remote voting, you don't need to have proxy voting. There used to be proxy voting in the House. Back in the day, as Toby has so kindly said, in the last century, there were occasions in which members could vote by proxy. That stopped, and I want to say that this was one of the changes that came about when the new management under Speaker Gingrich took over the majority in '95. I'm not entirely sure about that, so please don't hold me to that. Or somebody out there was probably typing in saying, no, it wasn't that. But it was discussed as part of that process. The decision was instead to authorize remote proceedings because I think of the desire to be able to have witnesses appear remotely, to allow members to be able to offer amendments remotely. As long as you're doing that, you don't need proxy voting. That's, I think, the argument.
Okay, great. Another question, has any thought been given to the use of electronic voting? And this questioner points out that the devolved Scottish Parliament, when established, was set up with electronic voting, which can deal with votes within minutes.
Right. Well, obviously, first of all, as I think everybody knows, there is electronic voting in the House in the sense that when the members are present in the House, you have your electronic scoreboard, which shows runs, hits, errors, and everything there. And those votes are done by card, and it happens electronically. The question is, is the House aware that there may be that operable and secure technology to permit remote voting? I don't know. I'm not privy to those conversations. I'm sure that the House Administration Committee is deep into the research on this, so that there may be examples of legislatures that have done so successfully. Will that be sufficient for the House to adopt it? I don't know.
All right, and I think one more we have time for. So can you explain what is going to happen once that review on remote voting is completed? What would then happen in order to determine, and who would have the authority to take action at that point?
Right. Well, what the resolution says, I'll tell you what the resolution says, which may or may not be what happens. But what the resolution says is that only if the Committee on House Administration makes that determination, they will provide that determination and the background materials to the Committee on Rules, which is basically seen as the tool by which the House leadership directs House proceedings and House operations. Then the assumption is that the Rules Committee will agree and will come up with the more specific regulations, including presumably another resolution that may lay out the details under which remote voting will take place in the House. But I think the assumption is that the Rules Committee will accept the recommendation of the Committee on House Administration and then move towards figuring out some of the legal authorities by providing the actual resolution and House rules to make it happen. But again, because the Rules Committee is an arm of the leadership can ultimately do what it wants. So what the resolution says and what may actually happen may or may not be the same thing.
Great, Noah. Thank you so much. This is very helpful to me and probably to our whole audience. We really appreciate it. Let's you and I go to a baseball game sometime when the ballparks are open again.
That would be great.
And I will see you at the end when we have our roundtable. So thank you.
Sounds good. I'll do my 7th inning stretch now then.
Yes, everyone, take a little stretch. So yes, thank you, Noah. So I think we're actually doing quite well on time. And what I'd now like to do is introduce our final speaker, Dr. Ronan Cormichan. Dr. Cormacain is a senior research fellow at the Bingham Center for the Rule of Law, British Institute of International and Comparative Law. What that means is that he is joining us from London. He is leading the Rule of Law Monitoring Project. The aim of this project is a systematic analysis of all government bills to assess whether they comply with rule of law principles. Dr. Cormichan was called to the Bar of Northern Ireland, has an LLM in Human Rights from Queen's University Belfast, and an LLM from the University of London in Advanced Legislative Studies. And Dr. Cormichan has also been a speaker in the past at our International Conference on Legislation and Law Reform, and I first encountered him in that capacity. Dr. Cormichan, welcome, and we're looking forward to your talk.
Thank you very much, Toby, and thank you to everyone and for the invitation and for all the work behind the scenes that has been done. I would like to talk in a little bit of detail about the principles for making law during the public health emergency. So Ittai and Noah have both talked about the practicalities of legislatures getting up and running. I'd like to talk a little bit about when they do get up and running, what kind of laws should they be making during the pandemic and what principles should guide the making of those laws. So in overview, I've selected 4 different principles here. There's a whole range of possible principles that you could go through, but for this presentation, I've just selected 4. And those are: number 1, legality, that it should be in accordance with the law. Number 2, proportionality. Number 3, scientific literacy. And number 4, that laws should be time limited. So I'll go through each of those in turn. On the first question then on legality, my basic point is that law does not fall silent in the war on COVID-19. Now, if there's any classical scholars amongst you, you might pick up on this reference back to Cicero, who said that law falls silent amid the clash of arms. And my point here is essentially that law should not fall silent, that law has a very important role to play during the pandemic. And my argument is that the emergency response should be in accordance with the law, and that law should be used as the instrument for making that emergency response. So it isn't the case that we can simply step outside the legal structure and say, this is an emergency. What has happened is so terrible that we just need to do whatever it takes. No, I say that the emergency, the way that we govern in response to the emergency should still be within the parameters of law. And there has been obviously a certain amount of literature written about this in the past. If we go back to Germany pre-World War II, Carl Schmitt, the legal philosopher then, said that there ought to be a sovereign power to dispense with the law during an emergency. And his essential argument was that some things are too big, the emergency can be too great, that it's not really, the executive shouldn't really be bound by law during that emergency, that they should be able to dispense with it. Moving up to the modern era, David Dissenhouse said that states of emergency are within the legal order. So even though something bad is happening, it doesn't mean that we should step outside the law, that we should still govern within the framework of the law. Now, we might change, the framework might be altered, but it is still a legal framework, and everything that we do still should be in accordance with the law. Bruce Ackerman, the American academic, writing in the context of the 9/11 terrorist attacks in the USA, he made his argument that law still applies during the emergency. So this is the central point about legality, that it's not enough just because it's an emergency to step outside the legal structure, that we still have to act within that legal structure. And there's an excellent paper that I've read by James Maxiner, published in Theory and Practice of Legislation. And he talks about the legislative response in the USA, and he talks about it being a government of men, not laws. And he's clearly harking back to the constitutional foundation of the USA and this idea that in the USA there is no king, but the law is king, and the idea that no one should be above the law. And his argument is that there is a strong, he doesn't say a risk, he say that it is actually happening, that in some respects, the USA is stepping outside the legal structure in its response to the pandemic. And I can't mention this idea of law falling silent amid the clash of arms without mentioning a very important case from the UK from 1941, the case of Liversidge against Anderson. And this was a case in the middle of World War II, and the case was about the extent of the executive's power during the emergency. And the case for the executive was essentially, we should be able to do whatever we want because it's an emergency. And the dissenting judgment of Lord Atkins in this case is a very powerful judgment, and I'll just read it out. He said, in this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which on recent authority we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. This is an encapsulation of the principle of legality, that you must still act in accordance with the law. So that was the first principle. The second principle is proportionality. And that simply means that the means are proportionate to the ends. Just because we are in a public health emergency, that might be the backdrop, but that does not therefore justify any response in relation to that. Ittai has already given a couple of very good examples of Viktor Orban in Hungary and illegitimate power grabs by the executive. Proportionality means that you can only do what is absolutely necessary and no more than what is necessary in order to achieve your legitimate public health aims. So you must take the least oppressive measure possible in order to secure that goal. So a case from the European Court on Human Rights of Enhorn against Sweden. And the case there was that the Swedish government wished to compulsorily quarantine a HIV patient. And the court held that this was not permissible because there was other less severe methods that you should take. This idea of proportionality is built into the UK legislation on emergency law. So I've quoted two pieces of legislation from the UK here, the Civil Contingencies Act of 2004 and the Public Health Control of Disease Act 1984. And it is that second act which governs a lot of the legislative response in the UK. And both these pieces of legislation say that the government, the executive, can make secondary legislation, but both these acts expressly state that that secondary legislation must be proportionate. It must be proportionate to the end result and proportionate response must be proportionate in response to the threat. I can quote, since we have so many legislative drafters here, I can quote one of the top legislative drafters from the UK, Stephen Laws, who is now retired but was first parliamentary counsel in the UK. And he said that it is highly desirable that whatever means are adopted for emerging from the crisis should, as a matter of policy, seek to respect the freedom and liberties of individuals to the maximum possible extent in the circumstances. So he doesn't actually say proportionality here, but this is implicit in what he's saying. You can do what it is necessary to take some fairly harsh actions sometimes, but they should be the least harsh actions that's possible in the circumstances. We've had two cases, at least in the UK, on challenges to the legislation that the government has introduced in response to the pandemic in Hussein and Dolan. So both these cases challenged the legitimacy of the UK laws, the UK coronavirus laws. And in both cases, the judges made an express point in their judgment of saying that the laws introduced were proportionate to the end result. And this was a crucial factor in making them lawful. If the courts had found that they were disproportionate, the courts may have ruled them unlawful, but proportionality is now being embedded as a part of the jurisprudence in the UK when it comes to emergency laws. The next principle, this is the third principle then. Coronavirus laws or emergency public health response laws must have scientific literacy. What I don't mean is that scientists should make the law. No one voted for a scientist. They don't have that democratic legitimacy. They don't have the authority to make laws themselves. There's an interesting article by Eric Windholz, and he talks about autocratic technocracy, and he was speaking in the Australian context. But the risk that the chief scientific officer or the chief medical officer would in fact be having an undue influence and would in fact be making these emergency rules. On the other hand, at the same time, we shouldn't be making laws that directly conflict with the science. We shouldn't have legislation as a principle for making emergency law. It shouldn't be in direct contradiction to what the science says. I'm giving you an example which is quite obvious here. Bleach is not a cure for coronavirus. The middle way is, I think, the best way, which is that laws should be scientifically literate, which means that they take the science into account. They don't have to do 100% of what the science or the scientists may say, but they should be led by the science. This is very much the catchphrase that UK politicians use, that we are led by the science. It doesn't mean that we will do everything that the scientists say, but we will be scientifically literate. We shall know what the science means. One specific aspect of that I want to just flag up now is the precautionary principle, which is an idea by Klaus Messerschmidt, which is that just because we don't have the final evidence, the final scientific evidence on something, shouldn't prevent us from taking action now. So it would be nearly too late to wait until we have the final scientific evidence before acting. Provided we have a proportionate response, we can act now. The final principle for making laws in emergency is the sunset clause or the expiry clause. Essentially, this means there is a time limit to emergency laws. They don't last forever. They should come to an end. They should be regarded as an aberration outside the normal process of making laws. They should be regarded as something different. So there should be an automatic expiry, or what's called in the UK and in other places a sunset clause, which means that the sun will set on the legislation. And again, quoting Bruce Ackerman in the terrorism context for making emergency laws, He said that defenders of freedom must consider a more hard-headed doctrine, one that allows short-term emergency measures but draws the line against permanent restrictions. And again, in the UK, we have that. Our Coronavirus Act of 2020 has a 2-year sunset clause. And when it was going through our parliament in the UK, a new clause was added which allowed for a review after every 6 months. Under our Civil Contingencies Act of 2004, any regulations made under it will automatically expire after 30 days. Our 1984 Act said that emergency regulations will automatically expire if they haven't been approved by Parliament within 28 days. I've already, I think, mentioned in the chat, Itai and I are general editors of the journal Theory and Practice of Legislation, and you can find a lot of very useful articles that I've mentioned on that website. And I can't not go without mentioning Toby's excellent book, The Legislative Drafter's Handbook, because I did cite some of it in my own PhD thesis a couple of years ago. So conclusion then, I would simply say the 4 points. The law still applies during the pandemic. We have the principle of legality. Second, we have proportionality. So whatever emergency laws we enact should be proportionate to the ends being sought. Thirdly, that the emergency laws must be scientifically literate. They must show an appreciation and awareness and have regard to what the actual science is. And finally, that there should be a time limit, that these emergency laws should automatically expire after a certain amount of time.
Thank you, Ronan. That was really wonderful, very enlightening, and actually extremely concise. So I applaud you for all of that. Please let me know how many zeros I should put on that check for the mention of my book. I do appreciate it.
Well, just our ordinary kickback will work fine, Toby, 2%.
Okay, great. So what I'd like to do now is, first I'm going to pose some questions to you, Ronan, that have been asked either in the Q&A or elsewhere, so that we can address some of the points that you make in particular. And then after we do that, in the time that's left, because I do think we do have a commitment to finish by the top of the hour, which is 2 o'clock for most of us, but it's later than that for you, and also for Itai. So we are going to finish by the top of the hour, but we do have about 18 minutes left. So the first question that I have, Ronan, is how do you deal with the fact that the very existence of an emergency is, to some degree, a political question? Here in the U.S., for example, there is I think a political disagreement about whether we have an emergency that relates to immigration on our southern border. We also have a disagreement politically over whether we have an emergency relating to climate change and global warming. So how do you expect questions like that to be addressed? Can scientists, is that an issue of scientific literacy, or is that an issue of something else?
That's a very good question, and quite a difficult question to answer, really. When I did some work for a Russian institution some time ago, and they asked the question, what is your procedure for declaring a state of emergency? And they were quite shocked that there was no formal procedure in the UK for declaring this is now an emergency. Which means, I think, that it becomes a political question, certainly depending on which jurisdiction you're within. It becomes a political question. Is this an actual emergency? I mean, I suppose some things are objectively hard to disagree with. When there was a terrorist attack on America in 9/11, that was clearly an emergency. A global pandemic, which is killing hundreds of thousands of people around the world, to me is an objective emergency. Climate change, when you look at the scientific consensus, is an emergency. But I do agree that it does require a political consensus, which can be quite hard to reach on whether or not in your particular nation does this particular event constitute an emergency. So I don't really have a hard and fast answer to that. It would be useful if there was a procedure set out in the Constitution for the Speaker declaring an emergency after consulting XYZ, but I'm not aware of countries having that type of procedure in place.
Excellent, thank you. So here's another question, and this actually is about proportionality, which is a concept we don't actually have in jurisprudence in the US. But how do you determine what is a proportionate law when it is made by a chief medical officer under a delegated power?
That will be partly subjective and partly objective. I suppose it depends who is making the judgment. If it's a court making that judgment, if it's a legislature making that judgment. It will involve, or it should involve, asking the question, what is the purpose of this measure? So the purpose is most likely to be in the background to stop the transmission of the virus. And there might be an intermediate question within that. How will this particular measure stop the transmission of the virus? And then I suppose you can come up with a range of possible outcomes. So let's say, take for example, we want to stop the transmission of virus in the shops. So we can either close down all shops completely, or we can require people to wear a face mask before they go into a shop. And then you can have a scientific debate or a scientific discussion about the effectiveness of each of those measures. And you might come up with the end result. Both those measures would stop the virus being transmitted, but the least oppressive measure of keeping the shops open but requiring the wearing of a face mask is the most proportionate response. So it's partly subjective, partly objective, and you can have these debates on the floor of your legislature. And if it comes to a court, then the arguments can be presented in a court about what is the proportionate response. And as part of that evidence, it's the same way that court will take evidence on any matter. They will listen to the evidence and they will weigh it up.
Thank you, Ronan. The next question is, really, I think what it boils down to is, why should we hesitate to delegate authority to scientific experts? In the modern regulatory state, we have done this, and why are we concerned now about doing it? Because science is so important and so much needed.
Well, if I can sort of make another classical allusion, Plato talked about laws should be made by philosopher kings because philosophers were the most wise of all people, and therefore they're the ones who should make the law. In a modern democratic state, we don't say that laws should be made by the wisest person. So why should we say that laws should be made by scientists? Because like philosophers, no one voted for the scientist, unless you're Angela Merkel, who happens to be a scientist in charge of a country. Because it's not the function of a scientist or an expert to make the law, it's the function to advise on it. But ultimately, it's the responsibility of the elected people to make those laws, or at least to finalize and give authority to those laws. I certainly wouldn't say that we shouldn't listen to the scientists. And I think that in the UK, the scientists have a very large and prominent role in making that law. And I absolutely agree with that. But ultimately, no one voted for the scientists and we can't vote them out. So the person who we vote for is the person or the people who should be making those laws.
Very good, thank you. I'm going to have one more question for you, and then I'm going to invite all of the panelists, all of our speakers to come back on in audio and video to have a little bit of a further discussion as we close this out. And by the way, I want to thank everybody who's been submitting questions in the chat. There are too many good questions for the time available, so I'm not able to ask all of them, but they're all greatly appreciated, and we really appreciate all of your interest. So Ronan, can you discuss ways that time limits or sunsets can be effective when the figure that has promulgated the emergency law gets to determine the state of emergency and the duration of the state of emergency?
Okay, this is a classic question about checks and balances in the system, and it's a very important, it is a procedural point in some ways, but it is a really important point. The bottom line, I think, is that it should require the authority of the legislature in order for the emergency laws to continue. And I think you have to decouple two things. Number one, the emergency, as in the physical pandemic, and number two, for how long we need the emergency laws. And it's impossible to say at the outset how long the actual emergency will last. And it's quite difficult to say how long the emergency laws will last. But there needs to be a point whenever the legislature is asked do you authorize this continuing for longer than 6 months, 1 year, 2 years? And there's lots of different ways you can have sunset clauses. So you can have a law which expires automatically unless Parliament says something, or you can have a law which continues indefinitely, but Parliament has the right to step in at any point and cancel it. So there's different sort of procedural ways, but I think essentially you need the authority of the legislature, the political representatives to authorize the continuation of the emergency.
Very good. Thank you, Ronan. And I think that concludes the questions I have specifically for you. Now, I'm asking if you could stay on, and if Noah and Ittai could join us. I have some questions that I think we'd be interested in hearing all of your views on. And I think the foremost really of all these questions is going to be this. We're currently in a pandemic. At a certain point, we will not be in a pandemic. What of these sort of changes and impacts that we have seen, what of these are things that are likely to continue into the future? And of those things, what are the things that we should be pleased about? And what are the things that we should perhaps be very concerned about? I'm going to, rather than have you all talk over each other, I'm going to ask you, Ronan, to tackle that first.
Well, hopefully, not many of the things that we're doing during the pandemic will continue. I think there's a real risk that executives will get used to legislating by diktat. So this is what's happening in the UK, and the executive get used to just passing decrees, which is not a way to govern. So that's one thing I hope will stop. In one of the articles that I've written before, I talk about this idea of socially distancing the emergency laws from the rest of the statute book. And I think that's an important idea to keep them separate. One of the things which I hope will continue is, I think someone in the mentioned already, electronic voting, remote voting in the Scottish Parliament. When I look at the UK Parliament and archaic methods of voting, it seems so stupid, to be quite honest. So if we can have a proper online democratic lawmaking like that, I think that would be one positive thing we can take.
Thank you, Ronan. Ittai, do you want to tackle that one next?
So I think the fear is mostly from two aspects that are very dangerous to democracy. One is that we mentioned power grabbing by the executive branch at the expense of legislatures. I could also say in parentheses, expense of courts as well. And the other one is rights infringing legislation, that the risk is that it would become a norm. And even if it's sunset clauses, and I agree with Ronan to a very large extent about sunset clauses, but one of the dangers of sunset clauses that psychologically there's a precedent that we said, okay, we had it once, and then we get used to it. And when we originally enacted, we say, well, it's only temporary and it's an emergency, so we'll allow things that we would not usually allow. But then, you know, the emergency passed, and now they make it permanent, but we already had it. It's a precedent. We already got used to it. And this is, I think, the most dangerous aspect. The positives, I tend to agree with Ronan. Maybe legislatures becoming more effective. The whole ideas of virtual, remote, electronic devices, I think, would remain to some extent. And to some extent, it would be positive that some aspects of it would remain. It maybe to be the most positive about it is the sense of urgency that I saw in some countries, that people actually were awoken to see that standing up for democracy and for the right of parliament to continue to do oversight, the right of people to protest, etc., I think became so strong now. Hopefully, those type of democratic awareness would continue after the pandemic is over.
Thank you, Ittai. And now I'm going to turn to you, Noah. Do you have any thoughts on this yourself?
I do, and my thoughts aren't so much unique to the legislative process or to the operations of legislature as just to normal working life. I mean, remote work is here to stay. I don't think there's any question about that. The more successful people are at being able to do their jobs, hundreds, whoever, wherever they may be, without actually being physically present with their colleagues, the more successfully they can do it, the more they're going to want to do it. There are a lot of things about remote work that make it easy. You don't have to put on a tie. You don't have to get on the subway to get to your office. There are opportunities for people who might not otherwise have been able to work to be able to work in a remote setting. The question that I have is, how does this affect how these institutions operate? In my office, for example, we have successfully onboarded, a word that I hate, by the way, but it's the easiest way to say. We have successfully brought on new attorneys this year, people whom I have not ever been in the same room with, and they are my colleagues. What does that say for the future traditions and the internal culture of an office and for the House itself now? When members aren't able to congregate in that teeming mass of humanity on the House floor. I noticed that somebody had a question. I'm trying to wrap this up, but somebody did have a question about what's going to happen when the new Congress gets sworn in January. Because what happens, if you ever watch that, it's a fascinating day because everybody is there. Everybody brings their kids and their grandkids, and it's just a hubbub, a cacophony of excitement, and everybody is taking the oath together and they get their pictures taken with the speaker. And it's probably the one day in the Congress where everybody feels like they're all part of something together. They feel the weight and the excitement of being part of this institution. I don't see how that's going to happen at the beginning of this Congress. I don't see how we're going to have the kids and the grandkids together. What is that going to say for how people in the institution work together? What do we lose by not being able to be together physically in the same place? So this is a trend that's going to continue, and I am unclear about the ultimate effects it's going to have on how the House operates.
Thank you, Noah. And to your point, I think you're speaking about society at large, and that is a terrific point, but it's also very much true, I think, of our legislators who rely so much on the FaceTime and the horse trading and the give and take that they have, the handshakes and the backslapping, all the stuff that they get to do in person. I mean, I think for just about all of our legislators, they're not introverts like many of us might be. They're extroverted and they rely and they feed on, they get their energy from being able to be in the same room and working the room. And so it definitely has an impact. Well, we're just about out of time. Thank you to our speakers. I'm gonna wrap it up with a few other housekeeping remarks. I want to thank our speakers, Itai, Ronan, and Noah. I want to thank again Larry Shapiro and Kathy Pagano from our organizing board who did so much great work putting this together. I want to thank the University of Pennsylvania Carey School of Law for providing all of the support to make this happen. And chief among that support is the law school's fabulous events coordinator, Neoshi, who's been working behind the scenes tirelessly and graciously to make everything run smoothly. So thank you. I also want to thank all of you in the audience for tuning in and giving us your attention. As we mentioned at the beginning, the work that we do here is, it really is a labor of love. We are mostly just a bunch of lawyers who have an interest in legislation and law reform and want to share that interest with the world. Every once in a while, we get together and in a nonprofit, nonpartisan manner, we put on a conference on legislation and law reform for the whole world. We do it in DC, and over the past decade or so, we've put on 6 conferences, and we have been able to attract speakers and participants from around the globe. We are honored and humbled to have your interest. As Kim mentioned at the top of this webinar, our next conference will be precisely 12 months from now, October 2021 in Washington, DC, and I very much hope to see you there in person in a COVID-free environment. So until then, stay safe, be well, and look for updates on our website, ilegis.org, ilegis.org. That is all for us today. Have a good afternoon. Have a good evening.